By 2019, it was estimated that 2.5 billion online images were stolen every day. The intent of today's episode is to make you aware of a few facts regarding photography and the law. It is my personal belief that as your photographer, just because I have the legal right to do something does not mean that I should. I respect the wishes of the people I photograph and believe in doing all that I can to develop a long-term trusted relationship, always working for what is best for you and your brand. Welcome to your iconic image. If you want to take control of your image and be a power player in your space, then this is the show for you. Here we will arm you with tools and information to help you grow your brand on purpose. I'm your host, Marlana Semenza, photographer and visual strategist. Now let's dive into today's episode. Ani Agrawal is an intellectual property attorney with a background in patent prosecution, patent litigation, and related IP advising. His current practice focuses on patent and trademark prosecution before the United States Patent and Trademark Office and in foreign countries. Welcome, Ani.
Hi, Marlana.
So I'm really excited to have this conversation with you because nobody talks about the legal aspect of using images and the ramifications of misstepping and crossing over the line. And while this conversation is going to be based on the law and what things are from a legal standpoint, we do have to let people know that they should not be construed as legal advice. For that, they would need to speak directly to an attorney.
Yep.
So
that's right.
Let's start with the very basics. I see an image online, whether it be on Facebook or wherever, and I decide, you know what, I really like this image. I want to use it. So I take a screenshot and I use it. Legal or illegal?
You should always presume that that is illegal. So copyright is really established as soon as an image or a song, anything is created, there is a copyright associated with that image. And that is true whether they federally register the mark or they've simply published it on a website. The creator has copyrights in that media that they've created, and that right extends to them whether they have federally registered the mark or not. So,
well, go ahead.
Anytime you see an image, you should always operate under the assumption that there is a copyright associated with it.
So even if it's, let's say, something that's nondescript, like flowers or a sunset, I should still make that assumption.
Absolutely. So the subject matter is not important in this case. It can be a person, it can be a sunset, an animal, animate, inanimate. It makes no difference. The photographer or the creator of the image has rights in that, and that's true regardless of the subject.
So what about photos of me? If a photographer sends me proofs, let's say, or I see my images being used on the photographer's website or in their social media, can I take a screenshot and use them myself?
Actually cannot. So that is a common point of confusion. People think that, the photo is of me. It's obviously I will have full rights in it. It is the same image I see in the mirror every morning. So there's, there should be no restriction. It's my face, my property. And that is not the case. What happens is when a photographer takes a photo of you, they own the copyright in that photo. So absent some sort of work for hire agreement where ownership is transferred to the subject of the photo, absent any agreement like that, the copyright is presumed to be held by the photographer. So you have to have permission from the photographer, some sort of license to be able to, use the photo. And it could be that you could use it for personal use or commercial use, but that is permission that you have to be given by the photographer and provided a license by them because they are the copyright holder, even if it is your own face on the picture.
So I think that's a mental shift for a lot of people because even though the images of you, we're not talking about you, we are talking about something that has been created by someone else. And it's that entity. So then you did mention that all images are copyrighted upon creation, correct?
That is correct, whether they're federally registered or not.
Okay, so then what is the difference between a copyright and a license?
So the copyright is, and I keep mentioning this, but absent some sort of work for hire agreement, a copyright is owned by the creator of the artwork, photograph, music. They own the copyright. And if you have a license to use copyrighted material, that is a right for you to use this image, say personally, on your own personal website. The license could allow you to use, for a business reason, to advertise a product or service. You could use it on, for example, we could use it on our law firm website, but we would need a license from that photographer to use it for a business purpose. And licenses can vary dramatically in what they allow. Some can allow your rights to modify the image. Some you can use it freely, but you just have to give credit. There's Creative Commons licenses. I think there's 7 different kinds of those, which allow a wide variety of use. Some licenses you have to give attribution, but you can use the image freely. In some licenses, you can use it for personal use, but not for business use. So a copyright is really complete ownership over the image. A license will specify certain ways you can use that image, and even certain time periods. It may not be exclusive, it may not be indefinite.
So if I have a license, let's say I have a full use commercial license for an image, do I need a copyright?
If you have a full use commercial license for an image, do you need a copyright? The question really is what do you want to do with that image? If your license provides you the rights to use the image in the way you want to, then you wouldn't need to have a copyright. You could use the image without infringing the copyright. But if you step outside the use that's permitted by that commercial license, for example, you may not have the rights to resell this image. That would be a copyright violation because that is not encompassed by your license. So depending on what you need to do, if the use you need is fulfilled by the license, then you wouldn't need the copyright. But anytime you step outside of that license, you cannot, it's not a free-for-all to do with the image what you please.
So what does that mean for me as a user if the photographer is retaining the copyright?
So if you're a user, you have a license to this image, if the photographer is retaining the copyright, it means that they can use the image in whatever manner they need to, either for their business, personal use. They have full ownership rights and they retain those rights in the image. So, I'll often see, you'll be on a photographer's website and often you'll see pictures of their work that they've taken. It is possible that those pictures, most of them are of people other than the photographer, of course. And in most of those images, it's very likely that the subject of the photo doesn't have rights in those images or has a limited license for personal use. And the photographer maintains all the rights. So they're able to use that image to say, look at the good work I do, or to kind of show their breadth of clientele. So the owner of the copyright retains full rights even when a license is granted to, a licensee.
So just to make this clear for everyone, let's say a family photographer takes these beautiful images of your family and you decide, gosh, I really would like to use these in my business to either help promote what I'm doing or on a billboard or any of those kinds of things. Can I do that?
You can if you have a license from the photographer to use that image for commercial purposes. Absent that license, there's, you don't have the rights to use it just because it's your child or it can be a picture of your own kid, and you have no rights to use that image without a license, allowing, in your example, a commercial use license.
So let me ask this. Does it change at all when there is the minor involved?
It does not change in terms of copyright ownership. The same rules apply. Now, there could be other state statutes that are involved when it's the use of a minor and you're identifying who the minor is. There could be some state law issues that come into play there. But in terms of federal copyright law and copyright ownership, there's no difference whether the subject is a child or an adult.
Okay. Which then brings me to the next odd thing that happened fairly recently. And everybody can look the details of this up just by Googling Jay-Z sues photographer. The abridged version of this is the photographer that photographed Jay-Z's original album cover, I believe, is either selling that image or or using that image in something that he is selling. And Jay-Z is suing him because he is saying that he never agreed to the sale of this likeness or for it to be used in this manner and things like that. Is what the photographer doing, just based on this information, because we don't know all the ins and outs of it, is that illegal?
What the photographer is doing in this case, I'm familiar with the case, is not illegal because, like we've been discussing throughout this podcast, the photographer has full rights in these copyrighted images. From what I know, I think this was the Reasonable Doubt album, and this was back in 1996. So, neither party was flush with cash and tying up all the legal loose ends. So this was done in a, traditional subject-photographer relationship where the photographer owns the rights in the photos. The photographer was paid for this photo shoot and was paid for the specific photograph that was used in the album cover. But all of the other photos that were taken during that photo shoot, those are all owned by that photographer. And, as far as the law is concerned, he has the right to use them in whatever way he sees fit. Now, what Jay-Z is alleging are states' rights issues. So he's alleging rights of publicity and, privacy rights that are being violated. And interestingly enough, Jay-Z's not arguing any federal violation of the law. These are just state rights issues that he is saying, my rights of publicity, I'm a famous person, and you're using my likeness without my permission. Because the photographer sells prints of these Jay-Z photos from that shoot for thousands of dollars. So he's making quite a bit of money on these images. At the end of the day, it's possible that Jay-Z is able to successfully prevent him from continuing to do this based on these rights of publicity, these state law issues. But Jay-Z would still not have the rights to use these photographs of himself for his own use. So he may be able to allege these states' rights issues to prevent the photographer from continuing to use his likeness, but he still will not own these photographs. And up until now, at least, the law is clear that these photographs are owned completely by the photographer.
So does it change at all when someone is famous or well recognized? Does it alter the situation?
Yes. So that's where the rights of publicity come into play. If you were to sell a bunch of pictures of me, no one would buy them. But, if you were to use photographs of somebody who doesn't have, the kind of notoriety that he has, it would be tough for them to allege that, they're suffering some monetary damages because you're using their likeness without their permission. So the rights of publicity come into play most often when you have, famous people.
And does that speak to the fact of their brand or their reputation, things like that? Is that kind of the area that's treading in?
Yeah. So that's a good question. Like, how famous is famous? Like, when are you famous enough to allege rights of publicity? There's no clear line on that. I mean, you would have to, kind of state the facts and try to make your case that, I'm famous enough. Fortunately, in Jay-Z's case, I don't think there's, that's not a borderline case. Well, and all of this really could have been avoided if back in 96, they contractually agreed that Jay-Z would own the copyright in all these photos. And if they treated it as a work for hire situation, then the photographer wouldn't have any of these rights and this would be a non-issue. And, conversely, if Jay-Z had signed off and maybe for a discounted price on the photography fee said, I'll give you the ability, I'll waive my rights of publicity and give you the right to use these photographs, then it would have been clear then also that the photographer had rights to do this. But my understanding of the facts was that there were no legal agreements in play at the time. So the default is the photographer owns the copyrights and can do with them as he pleases.
So tell us a little bit, because I've never heard of rights of publicity. Tell us a little bit more about what that really means.
So it's kind of it comes out of a right to privacy. And what it is it is a, it really comes out of a common law doctrine. It's not federal law. Different states have different rules. And there are even some carve outs that some states have for photographers where they're not subjected to, absent some agreement, they're not subjected to rights of publicity being asserted against them. So it's kind of a state patchwork of laws. I think maybe about half of states have something like this. New York and California do have it. And it says that, to exploit somebody's public persona for financial gain is essentially a violation of their privacy and their rights. And that's where it stems from. So again, it's not a federal law. It's not uniform across all the states, and it differs between, all 50 states, with about 25 having them.
Interesting. And what about people who think, well, you know what, I'm going to just use this image, and if I get caught, I get caught. First of all, people need to know that there are ways to track images. Yes. And the other thing that we should probably dive into a little bit here is let's say you do get caught using an image that you don't have the license to use or the authorization to use. What's best case and what's worst case?
So first of all, as you said, there are ways to track these images. Many images are embedded with metadata. And I know in Windows, for example, you can right click on an image file, go to properties, and it's, EXIF or metadata. It lists oftentimes it will list the copyright holder and even include a copyright notice in that metadata. And there are programs that can kind of crawl through the web and pick these up. Getty's and all these big players in the image industry have these kind of programs. People can do reverse Google image searching, where you submit a picture of a photograph, and a photographer could certainly do a reverse Google image search and see where their images are coming up. So even if somebody scrubs the metadata, they're absolutely not in the clear, because there are other ways to detect these photos. So say this happens and you get caught. Chances are you will get, in a best case scenario, the photographer, the copyright holder, reaches out to you and says, I want to make you aware, this is our photo, this is our image. Please take it down immediately and do not use it in the future. That is the absolute best case scenario. What I've usually seen is you get a DCMA takedown request from the copyright holder, and then they want understandably, they want some sort of financial compensation for the commercial use, for example, of their photograph or for their image. If it is proven that you knew that you were infringing somebody's copyright, and that's called willful infringement. If it's proven that your infringement was willful and their copyright is registered, you can actually be subjected to statutory damages of $150,000 per infringed, image. So for every image you infringe, if it's willful and they have a federally registered copyright, you can be assessed statutory damages of $150,000. Now, the clients I've seen, usually that's not alleged. Usually that's not sought after, but it's definitely in the thousands. So, what could have been avoided very easily by searching for, public domain images or simply purchasing an image for, some of these images are inexpensive. It's $50 to, under $500 for, some really high resolution ones. Instead, they get, these letters demanding thousands of dollars. And if it's a big enough player, they can certainly take them to court. And then you've got attorney's fees. If the infringement is willful, you can be liable for the copyright holder's attorney's fees as well. So it can get very expensive very fast for something that's pretty easy to avoid.
So what is the one thing you would like everybody listening to this to kind of remember and take away from this conversation?
So I think with respect to these images, whether they're photographs or, digitally created images, I think what you need to always assume is that the image is copyrighted and that you do not have the rights to use it. And I think if you operate from that framework, you'll always be, playing it safe. There are ways to use, and I'll just use Google, for example, because I'm familiar with it. There's ways to search images by license type. So you can search for only images that are in the public domain, or only images that have, free for personal use licenses attached to them. I think anytime you see an image, whether it has a copyright notice on it or not, just assume it's owned and that you don't have the rights to use it.
When in doubt, you don't have them.
That's right. Yep. Especially with copyright, because like I said, that's established at the point of creation, point of publication. It's not, you're not required to file on it. And I've seen, there's been cases where people will see the infringement, then they will file, they'll see the infringement, they will then register the copyright, and then they will sue for infringement. So now you're infringing a federally registered copyright. So it's always just safe to assume you don't have the rights to use the image. And there's plenty of very inexpensive images out there that you can get a license for, and plenty of free images as well.
Great advice. Okay, with that, Ani, I just have 4 final questions for you.
Okay.
First one is, what's the best piece of advice you were ever given?
Best piece of advice. I was actually thinking about this morning because one time someone told me that if you're worried about something, try to remember what you were worried about a week ago. And I often find that kind of puts things in perspectives for me, because I can very seldom remember what I was worried about a week ago. So chances are what's bothering me now is not going to be a long-term issue. So that's it's probably one of the good pieces of advice I got from a dear friend.
Share with us one thing on your bucket list.
Bucket list. I mean, there's of course many places I want to travel to, but one thing I would like to do is kind of have a chance to establish a connection with a lot of my relatives who are still in India. I have a lot of cousins who I haven't seen in a long time, people I haven't even met yet. I think it would be great just to be able to, go there and be able to connect with everyone at least once.
Have you ever been?
I've been several times, but it was always in summers when I was a kid, and I had very little agency about what the plan was while I was there. So I'd like to go back now as an adult and kind of see, meet all the siblings, or not siblings, but cousins and everyone that I haven't yet seen.
Nice. So when the toy companies finally get around to making an action figure of you, what 2 accessories will it come with?
So this one is easy. It would be a toothbrush and a guitar. I think
Love
when I
it.
was a kid, when I was young, that's basically, if I had those two things, I could be anywhere for, hours or nights at a time. And I think that's probably the two accessories that they would use. It wouldn't be the most exciting action figure, but that's an accurate description.
Love it. And the last thing is, if anybody does need legal advice or wants to speak with you, how do they find you?
So the best thing to do is to go on our website. It's nkpatentlaw.com. NK, naughty kangaroo. It's an easy way to remember it. Patentlaw.com. And under our team, you can find all my contact information there, along with everyone else in our firm.
Thank you. Thank you so much for that. And thanks for being here.
It's a pleasure. Thanks, Marlana.
Thank you for joining us. Once again, I'm Marlana Semenza, photographer and visual strategist. Please comment, like, or share this episode, and don't forget to subscribe so you don't miss a thing. For more information on how I can help you create your iconic image, visit marlanasemenza.com.